All right, hello everyone. Welcome to today's webinar. I'm seeing that heaps of you are jumping on now, so that's excellent. All right, so today's webinar, as you all know, is on Queensland's new Human Rights Act, and it's very exciting because we've got three wonderful presenters here today. We've got Matilda Alexander from Legal Aid, we've got Deborah from Human Rights Commission, and we've got Janelle over here. Janelle's jumping in. We've got so many people in the room, it's a full house, so we're going to be playing musical chairs a little bit. But before I start, I'd like to do an acknowledgement of country and just acknowledge the Aboriginal elders past and present and emerging. And this video is for community legal education purposes only. And my name is Ellen Limerick and I'm the Community Legal Education Officer here at Legal Aid. And I'm going to go through some quick housekeeping before we get into the presentation, because I know many of you may not have been to a Legal Aid webinar before. We run around 10 to 12 webinars a year here at Legal Aid, and we'd love for you to be a part of our program. So feel free to send me an email if you'd like to subscribe to our program. It's absolutely free, government service. That's great. I'll go through email addresses and how to subscribe at the end. But anyway, this webinar is being recorded, so it will go up on our YouTube channel afterwards. So feel free to share that link with your colleagues or anyone who's missed out. And I'll also send you a link after the webinar with that YouTube link. So there's also lots of information on our information for community workers and carers page on our Legal Aid website. So feel free to jump on that page if you need any more resources and help. And if you've got any technical difficulties today, please call that number on the screen. Okay, so we've also got a handout today, and the handout is a copy of the PowerPoint slides. So on your right-hand side of the screen, you'll see a handout bar. Now you can open that bar and click handouts and download a PDF copy of these PowerPoints. If you can't work out how to do it, I'll also send you that PDF after the webinar. If you've got any questions, there's also a question panel in that right-hand side. Feel free to type in your questions as we go, but we probably won't answer them till right at the end. So we'll save about 20 minutes at the end. Now, because we've got three speakers, we're probably going to go over time. So if you've got an extra 15 minutes to spare today and you can hang on till 11:15, please do, and we'll get through all those questions. Okay, I'm going to start with a poll. We'd just really like to know a bit more about you. So what area do you work in? Now, do you work in Southeast Queensland, Far North Queensland, regional, or are you not from Queensland? If you're not from Queensland, this webinar might not be very useful. What do you think? Okay. All right, so I'm just going to give you a couple more seconds to enter your answers in, and then I'm going to close off this poll. Okay, closing the poll and sharing the results with you now. Okay, you should be able to see this poll results on your screen. So 73% of you are from Southeast Queensland, and then we've got 12% from Far North Queensland and 13% of you from regional Queensland, and 1% from outside of Queensland. Welcome, we hope you find this webinar interesting. Okay. Now I've got one more poll to do, and we just would like to know a bit more about you. So just asking you where you work. Do you work in a community legal centre, legal service type organisation, or are you a community health education worker, or are you from a government department? Do you work in a electorate office dealing with members of the public on a day-to-day basis? Or do you not fit into any of those categories? in which case please send me an email because we'd love to know where you're from. Okay, just giving you a couple more seconds to answer that question, and then I'm going to close the poll. All right, sharing those results now. Oh, great. Okay, so we've got 23% of you from a community legal centre or some kind of legal service provider. And then we've got almost half of you from the community health or education sector. And then quite a lot who don't fit into those categories either, some other. Okay, welcome everyone. All right. So that's all from me. I'm going to hand over to Matilda, and she's going to get stuck into the presentation here. All right, thanks. Swap chairs with you, Janelle.
Okay, welcome everyone. Hopefully you're all as excited about the upcoming Human Rights Act as I am. This Act is important because it protects the inherent dignity and worth of all people. The objects of the Act are to protect and promote human rights, to build a culture in the Queensland public sector that respects and promotes human rights, and to help promote a dialogue about the nature, meaning and scope of human rights. It allows, it gives human rights to individuals, and it puts some responsibilities for decision making on government and also on any entity that performs government functions. It takes full effect on the 1st of January next year. So I'm going to talk to you about which rights are protected. So we're going to do that first, which is slightly different to the outline we've got up there. So there are 23 fundamental human rights and freedoms that are protected by our Human Rights Act, and these are mostly civil and political rights, and we've also got a couple of economic, social and cultural rights. The first right that's protected is the right to recognition and equality before the law. So everyone's entitled to equal and effective protection against discrimination and to enjoy their human rights without discrimination. This is similar to the protections provided under the Anti-Discrimination Act and includes, but is not limited to, discrimination that is protected under the Anti-Discrimination Act. So in the areas like work or education, state laws and programs, and for the reasons provided in that act, like race, age, sexuality, gender identity, impairment. So for example, this right might be relevant when trying to access courts, healthcare, or education. The second one is the right to life. Now this does not include decisions about abortion. It means that every person has the right to life and not to have their life taken. The right to life includes a duty on government to take appropriate steps to protect the right to life. So for example, this might be relevant in coronial inquiries into deaths in custody or suicide, or things that have been reported, like reported domestic violence deaths. Your right to protection from torture and cruel, inhuman and degrading treatment is also protected. So people must not be tortured. Torture is a very high bar involving very serious treatment and conduct. People must also not be treated or punished in a cruel, inhuman or degrading way. And under this right is also the protection for people having medical treatment or experiments performed on them without their full and informed consent. So this right might affect how places of detention operate, or the use of force or restrictive practices against people with disabilities. The next right is the right to freedom from forced work. A person must not be forced to work or be made a slave, and a person is a slave when someone has complete control over them. So this doesn't include things like a work order required by a court as part of a community service order, or emergency work, or work that forms part of normal civil obligations like jury duty, compulsory fire service or community labour, like work for the dole schemes. But consider whether work under one of those goes beyond what is normal in those kind of situations. The right to freedom of movement is next. People can stay or leave Queensland whenever they want, as long as they're here lawfully. They can move around freely and choose where they live. This right also means that a person can't be arbitrarily forced to remain in or move to or from a particular place. This right might be relevant to mental health treatment orders, residence conditions imposed by court or parole board, police powers in public spaces, or the rights of protesters. Next is the right to freedom of thought, conscience, religion, or belief. This right's got two parts: a freedom to think and believe whatever you choose, which is an absolute right, and a freedom to demonstrate your thoughts or beliefs publicly, which is more likely to be limited as necessary in a free and democratic society. This right may be relevant in a public education setting, restrictions on religious dress, or in planning decisions about places of worship. Next is the right to freedom of expression. There are two parts to this right as well: the right to hold an opinion, which is again absolute, and the right to express that opinion, which has various limitations. Expression includes in writing, verbally, in print, in art, or in other medium. So it's quite broad. In general, the right to express an opinion might be limited in order to respect the rights and reputation of other people, or for the protection of public safety and order. Some examples of this might be threats of violence or property damage or hate speech. Situations relevant to this right could include refusing prior approval for a public protest, or restricting where an activity can take place, or the censorship of materials. Next is your right to peaceful assembly and freedom of assembly. On the next
slide.
Yes. People have the right to join groups and to meet peacefully. This right extends to all forms of association with others, including but not only for political purposes. The freedom to join trade unions is an example of freedom of association. So decisions that regulate membership of groups or associations, or prohibit membership in a group or association, like a motorcycle gang, might be relevant to this right. Next is the right to take part in public life. Every person's got the right to take part in public life, such as the right to vote or to run for public office. This right might be relevant to things like a council's decision to ban someone from a public building or a space. Property rights. People are protected from having their property taken unless the law says it can be taken, so not arbitrarily. This right doesn't include a right to compensation though. The next right is the right to privacy and reputation. This section looks small but actually protects a whole lot of things. Privacy is a very broad concept and extends to a person's private life more generally. So it protects an individual against interference with their physical and mental integrity, including appearance, clothing, gender, and sexuality. It may cover the provision of DNA, biometric data, or blood testing. A person's name has been found to be private information in a case regarding a police request. Privacy also covers private family life, and recognising broad and diverse family structures. Unlike the Victorian Act, our Act does not explicitly exclude the right to found or expand a family. Privacy also includes the protection of your home life, and home includes, but is not limited to, where you're living. Privacy also includes protections for your correspondence, including phone calls, letters, emails, that kind of thing. Finally, this right protects your reputation, similar to the way defamation laws work. So to sum up, everyone's got the right to keep their lives private. Your family, home, or personal information can't be arbitrarily interfered with. And this might be relevant to police powers, people in state-run care or detention, or the government's collection or publication of your personal information. Next is your right to protection of families and children. Families are entitled to protection, and children are also entitled to protection in accordance with their best interests. And this is said to be one of the paramount rights, the best interests of the children. This right may be relevant in things like child protection proceedings or in tenancy matters, for example, where a family is being evicted. The next right is cultural rights generally. This allows people from a particular cultural background to enjoy their own culture, profess and practice their own religion, use their own language, and participate effectively in cultural life. And using your own language is both in private and in public. This right is not limited to minority groups. And it might be relevant to a failure to provide interpreters or, again, in child protection proceedings, which deprive a child of access to their culture. Cultural rights specific to Aboriginal and Torres Strait Islander peoples. Now, our provision here is the strongest one that I've seen out of in Australia. It recognises that Aboriginal and Torres Strait Islander peoples in Queensland hold distinct cultural rights. They include the right to practice their beliefs and teachings, use their language, protect and develop kinship ties, and maintain their relationship with seas, lands and waterways. This might be relevant to decisions that interfere with access to a place of significance, regulate commercial activities on traditional lands, or decisions regarding crime or mental health. It may also be relevant, again, in child protection proceedings. Your right to liberty and security of person is the next one on the next slide. Everyone's got the right to freedom and safety. To take the second part first, the right to security is similar to the right to life in that it means that reasonable steps must be taken to ensure the physical safety of people who are in danger of physical harm. The first part of this right is more fully expanded in the Act and talks about the deprivation of liberty, which is not limited to prisons, but could be any place of detention where control is assumed over the movements of another person. This might be locked wards in hospitals, aged care homes, watch houses, or psychiatric institutions. Deprivation of liberty does not include temporary restrictions such as stop and search powers of police, which are better described as affecting the freedom of movement. The right to liberty includes the right not to be arbitrarily arrested or detained. If the law does allow for the deprivation of liberty, such as the criminal law, there are certain protections under this right, such as the right to be informed about the reason for arrest and the obligation to be brought before a court and then tried without unreasonable delay. This section confirms you can't be imprisoned for failing to pay a debt as well. Next is your right to humane treatment when deprived of liberty. People have the right to be treated humanely if they are accused of breaking the law and are detained. The underlying principle is that a person's rights should only be limited by the confinement itself, not by additional factors. This section may be relevant to the detention and treatment of people in prison or in other places of detention. You now also have the right to a fair hearing. A person has the right to a fair hearing, meaning that the right to have criminal charges or civil proceedings decided by a competent, independent and impartial court or tribunal after a fair and public hearing. Various factors will indicate if a court or tribunal is competent, independent or impartial, including if it's established by law, if it's free to make decisions without interference, if its officers have security of tenure, and a range of other factors. In terms of the public nature of the hearing, media or other parties can sometimes be excluded from a hearing in the public interest, but decisions should be made public unless there's a good reason for a suppression order. Rights in criminal proceedings are protected. There are a number of minimum guarantees that you have when you've been charged with a criminal offence. These include the right to be told the charges against you in a language you understand, the right to an interpreter if you need one, the right to time and facilities such as a computer to prepare your own case or to talk to a lawyer, the right to have your trial heard without delay, the right to be told about legal aid if you don't already have a lawyer. You're presumed innocent as well until proven guilty, and you don't have to testify against yourself or confess to your guilt unless you choose to do so. Children also have particular rights within the criminal process, and a child charged with a crime who's been detained without charge must not be held with adults. They must also be brought to trial as quickly as possible and treated in a way that's appropriate for their age. Children are entitled to opportunities for education and rehabilitation within detention. People have the right not to be tried or punished more than once. So you can only go to court and be tried once for a crime. So if you're found guilty, you'll be only punished once, and found innocent, you'll not be punished. There's laws protecting against retrospective criminal laws. So a person has the right not to be prosecuted or punished for things that were not criminal offences at the time they were committed. Moving on to the economic, social and cultural rights that are protected under the Human Rights Act. This is the first one here on the next slide, is the right to education. This says every child has the right to have access to primary and secondary education appropriate to the child's needs. The right to education also says that every person has the right to have access based on the person's abilities, which takes into account like prior study or academic achievement, to further vocational education and training that is equally accessible to all. Now, it's important to remember here that private and non-government schools are not required to comply with the Human Rights Act, although they can choose to opt in if they want. And this section is intended to be consistent with the Education General Provisions Act, so the other laws about schools in Queensland. And so it provides rights in relation to public education service delivery. This right could protect against the introduction of huge public school fees, for example, or prevent school closures, or require measures to create formal or substantial equal approaches to protecting vulnerable groups of students. The last right I'm going to talk about today is the right to health services, which is unique in Queensland. The other jurisdictions that protect human rights don't protect this one. So everyone's got the right to access health services without discrimination. And this right also states that nobody can be refused emergency medical treatment. This right is not protected in any state and territory, and it's not intended to encompass rights relating to the underlying determinants of health, so the right to food or water, social security, housing and environmental factors. However, it could be relevant to laws, policies, acts or decisions about health facilities, hospitals, health information services and things like that. So now I'm going to hand over to Janelle to talk about some case studies.
Excellent, thank you. Okay, so we have all of these rights, but what do they mean for you in practice? So I'm going to run through 3 case studies quite quickly. They've been adapted from the work that Ben Schockman from Victoria did for us at the start of the year. And then the 4th case study will look at compliance, because we're getting quite a few questions about that. So you could be a community legal sector lawyer, you could be a social worker, a case worker, a staff member in a care setting, and you hear about situations and you think, I think some human rights might have been breached here. So I won't go into how to make a complaint, because Deborah will be doing that at the end of the presentation. So in the first case study, we've got Amanda, who is a 15-year-old person of Aboriginal and Torres Strait Islander descent. She's stopped and questioned by the police about a criminal incident that has recently occurred. Amanda and her family are known by the police, and when the police try to stop her, she tries to keep walking. So the police say that she's uncooperative and is taken into custody for further questioning. They leave her there for 4 hours and is released after they realise she had no involvement in that incident. So the first thing to do is recognise who has rights in this scenario, and that is obviously Amanda. And then we start to consider what rights might be relevant in this situation. So the first one might be recognition and equality before the law, as it appears that Amanda has been targeted because of her Aboriginal and Torres Strait Islander descent. As her family are known to the police, this could trigger a right to protection for children and families, particularly if they are being unreasonably targeted by the police. Being detained by the police may trigger the right to freedom of movement, and due to her age, rights relating to children in the criminal process, the right to a fair hearing or rights in criminal proceedings may also be triggered. And each of these 3 rights apply to children and the way they are treated by police in the criminal justice processes. So those are some of the rights, but then are those rights being limited? And it appears on the face of it that they are, because Amanda has been targeted and detained by the police. So the next question to think about is whether those limits are reasonable or not. So the police had no evidence of her involvement in the incident. They appear to have targeted her because her and her family are known to the police, and on the facts, it appears to be that those limits would be considered unreasonable. What can Amanda do? She needs to lodge an internal complaint with the police to start off with, and then depending on the outcome of that, she could lodge a complaint with the Queensland Human Rights Commission.
And Deborah's going to go into that later, how to lodge a complaint.
Exactly.
Very important.
Very important. So we'll move on to the next case study.
And also, if you're listening, feel free to put in the question box what right you think is being talked about in the case study.
Absolutely. So in our second case study, we have Sarah. So she's a resident in a state-run service for people with disability, and she's been there for 4 years. She needs assistance from the staff with eating and personal hygiene, and when her brother comes to visit, he finds that Sarah is malnourished, and the bedding and also her room has not been cleaned in some time. So he speaks to the manager about the situation and is told that due to resource constraints, staff can only do so much for each resident. So obviously from the facts, it appears that Sarah is the person with rights in this scenario.
And what rights do you think are we talking about? Put them in the question. We'd love to see who gets them right.
Quick typing.
Yeah, quick typing before Janelle goes through the answers.
You've got a little bit of extra time because I have a little extra note on this one.
Okay.
While Sarah has the rights in this scenario, if the right to work was part of the Human Rights Act, which includes things like just and favourable conditions at work, then the workers would have rights as well. But that isn't part of the Human Rights Act, so the workers don't come into that category. Okay, so what rights? Sarah, have we got any right to life? Yes.
Someone said right to life. Well done.
So what else? Sarah has a disability, so the right to recognition and equality before the law could definitely be relevant here. As one person has said, the right to life could be relevant, and inhumane or degrading treatment could definitely be relevant with regards to the unhealthy conditions. So what are some of the limitations on Sarah that we need to think about? Sarah would be being discriminated against if the other patients in the facility had been treated appropriately and she wasn't being, so she's been discriminated against. However, if the level of treatment is based on Sarah's status as a person with a disability, then that could be grounds for discrimination. The malnourishment may provide grounds for the right to life, as lack of food and water could be placing her life literally at risk.
Yeah.
And inhumane and degrading treatment, well, the lack of hygiene due to the uncleanliness of her room and her bedding could be considered inhumane or degrading, particularly if she's also in a state of uncleanliness as well. Are the limitations reasonable? Arguably no. That seems to be quite a simple answer. And the malnutrition in particular is a serious concern and could be placing her at significant risk. So what can Sarah and her brother do? Lodge an internal complaint in the first instance with the service, and then depending on the outcome can raise it with the Queensland Human Rights Commission. They could also lodge a complaint with the Health Ombudsman as well. So a couple of avenues for Sarah in that setting. All right, case study number 3.
Okay.
It's a bit longer, this one, so if you're reading faster than I can talk, throw some of those rights up into the comment box. Adam has lived in public housing for 12 years as the sole tenant, and he lived with his partner Molly for 3 years. Unfortunately, Adam passed away, and Molly notifies the department. She's told that because she's not on the lease agreement that she has to move out. So she tries to provide the department with evidence of proof of address, but the department won't budge and tell her she has to leave. Molly has no family in Brisbane that she can rely on, and her child is very happy at the local public school. So she's a low income earner, and she is very concerned that her and her child will become homeless. So who has rights in this scenario? Molly definitely, and you could also say that Molly's child also has rights here as well. It could be the protection of families and children, property rights and right to education for Molly's daughter are relevant. And are those rights being limited? Well, if Molly is evicted from the property by the housing authority, then they would be limited based on her connection to property, the local community and the school as well. The property right is obvious in that sense that if Molly is evicted, she loses her home, and the right to education, because if Molly is evicted, she has to move to a new area and is unable to get her child into a school, then the right to education is also limited. Are those limitations unreasonable? On the facts, I would think that you could argue that a decision to evict Molly and her daughter would be arbitrary and disproportionate as a response, and that would make the limitation itself unreasonable. It would depend on a range of factors like the internal policies and procedures, the legislation that's governing that particular housing authority. And also if there were alternative housing options available for Molly, so maybe she needs to move out of that property, but they can facilitate her starting a tenancy in a different property. The right to education could go two ways. If Molly can get her daughter into another school, then it becomes negligible. But if Molly's evicted and becomes homeless and her daughter can no longer attend school, then her rights have been unreasonably limited. And same process is internal complaint with the housing authority in the first instance. Those internal complaints are required under the Act, and then depending on that outcome could raise it with the Queensland Human Rights Commission. So the last one that I will go through case study 4 is just some examples on compliance. So we've been getting quite a few questions, not just from the Community Legal Centre, but also from other sectors about if they were a functional public entity under the Act, how would they comply? So one of the things that organisations could do is look at their internal policies and procedures and see if they need a quick tweak, a little bit of an update to make sure that they are appropriately reflecting human rights. And this could include looking at things like intake procedures, looking at complaints mechanisms, and any other document that you think needs that reflection of human rights in there. Some of the other examples have come out of Victoria. Obviously, their Charter of Human Rights has been around for a long time, so we're lucky in Queensland that we can look to Victoria and the ACT to see how they have implemented and rolled out their human rights legislation. So some examples are that several disability support organisations have established human rights committees, and they work through are the central point of call for working through any human rights issues and how to continually improve their service delivery. So they review things like mandatory human rights checklists that are used for each new client in their service. They look at the wording of organisational policies and procedures. They look at grievance complaint mechanisms, or make recommendations to workers about any practice changes that they need to implement. Another organisation looked at their human rights processes through their quality standards programs. So they recognised that they needed to have a strong understanding of the day-to-day impacts of rights across the organisation, and came up with this way of making sure that culture change was occurring in the organisation. They realised that it was unlikely that procedures would be implemented properly, so they added into their quality standards programs, as well as their staff training and induction, and they were able to get a greater take-up of the rights-based framework from people performing day-to-day operations. Some organisations chose to do a watching brief. It's not as relevant for Queensland because we've got these examples from Victoria and ACT, as well as obviously New Zealand and the UK. So there are a lot of ways that we can make sure that we are ready and compliant when the Human Rights Act kicks off on the 1st of January. And finally, complaints procedures. So one organisation in Victoria expanded their complaints mechanisms to receive non-verbal and non-written communication methods to make sure that their complaints mechanism was tailored for people who might have communication difficulties. Someone else redrafted their complaints policy to be around principles of natural justice. and their goal was to reconcile the client's interests and ensuring that fairness and justice are being met. So one of the things that we are developing from Community Legal Centres Queensland is a compliance guide. So we're trying to pick up all of these tools that have been developed down south and overseas and meshing it together. It will be tailored for the community legal sector, but it will be available on our website, and we're hoping to have a draft of that ready by the end of October. So I will hand over on complaints mechanisms.
Okay, thank you. So a very simple way of looking at the new Human Rights Act could be caught in 3 words. So when there's a discretion, you need to think about it and then think of the dignity of the person. So the least restrictive way of making a decision or acting in relation to that person. So if you need 3 words, discretion, think, dignity. The Act relates to both government and also to functional public entities. And I know there's a lot of people in the webinar today who may be public functional entities, so performing functions of a public nature for the government. So that includes a lot of community workers. So I understand a lot of you may be both public entities. You may receive complaints about your own services, but you may also be supporting your clients to make complaints if they feel that their human rights haven't been met. So the focus of the Act is on internal resolution. So what the Act requires first is that if the person feels their human rights haven't been complied with, then they need to make a complaint to the public entity who's providing those services. There's no prescription in the Act about how that complaint needs to be made, so it's a good idea to go through the formal complaint process if there is one, but if there isn't a formal complaint process, then you just need to, a verbal complaint would be satisfactory. The question arises, what is a human rights complaint? Your clients may not know all of the information Matilda's just been talking about all the different human rights and what they need. They don't need to know that. They just need to make a complaint about the services they're receiving. And it is important that you as a public entity have an understanding of all those rights so that you can recognise when the complaint is about a breach of the human rights, so that you can adopt best practice and respond to that complaint appropriately. Having said that, if there are complaint mechanisms in place already which are best practice, and you have a process in place where you listen to people's complaints and you try to respond to them, taking into account their concerns, then that really should already be meeting the requirements of the legislation. But this is really just, it's another way of making decisions. So just like we're used to procedural fairness in making decisions, we're used to thinking about privacy. This is just another thing that we have to take into account in making good decisions, and that is people's dignity and people's human rights. So the Act seems to be designed to embed that into culture in the Queensland government, and also really also into all services who are providing services to the public. So with the complaints process, the first step is to make the internal complaint. The Act says that the public entity has 45 business days, and this is the next slide. The public entity has 45 business days to respond and resolve that complaint.
Which is longer than other periods.
It's a very long time. According to, I think, national standards of complaint processes, 28 days, 20 calendar days. So 45 business days is actually 9 weeks, which is a very long time.
Very good news.
Yeah, very good news. I guess if you're a public entity and you're wanting to resolve the complaint, if you are say the examples that we talked about with Sarah in the disability service, and her right to life is at risk, it's too long. So there are provisions in the Act to shorten that time period for the Human Rights Commission. So if someone makes a complaint and it's an urgent matter, there's a risk to life or even risk to education, the example of Molly that we talked about and her daughter, it's essential that you make the complaint first to the public entity. That has to be done before the Human Rights Commission can accept a complaint. But if you have made the complaint, even if it's the same day, then you could lodge a complaint with the Queensland Human Rights Commission, And we have this discretion in our Act to shorten that time period to deal with the matter as an urgent matter.
Right, yeah.
And so we could deal with those matters urgently. On the other side of things, if we receive a complaint and we speak to the public entity involved and they are really trying hard to resolve the complaint and they're nearly there, they need a little bit more time, then we can talk to the complainant and the public entity and see if it's worth giving them a bit more time to try and resolve the complaint.
Yeah.
This is a new area for everyone. The public entity may have received a complaint and not even know that it's a human rights complaint.
Yeah.
They may not have recognised it like that. So we might receive the complaint, we recognise it as a human rights complaint, we let them know we've received it. And then if an internal complaint's been made in 45 days has not passed yet, we would let them know we've received it and say, after 45 days, if this isn't resolved, we'll be dealing with this.
Yeah.
If they need more time, we might negotiate some more time between to see if it can be resolved.
Okay.
I think the next slide. So, is there more appropriate? Yeah, so there's a fair few preliminary inquiries that the Human Rights Commission may undertake when we receive a complaint. So it's different from, we receive anti-discrimination complaints, and I think that's the first thing to not forget is that there's just one complaint form that's made to the Queensland Human Rights Commission. There's not a human rights complaint and an anti-discrimination complaint. You just make a complaint to the Queensland Human Rights Commission, and there'll be an opportunity for you to tick whether you think it's a breach of your human rights, what those human rights are, and also if you think there's been some discrimination.
Can people do these complaints online? Will you have that process set up?
Yep. We currently have an online form, and we'll be updating that to include human rights.
Cool.
There's also a Word format document you can lodge by email, and also you could just, it does have to be in writing, so you can send it this paper with your name and address. So the main thing is it's in writing. It includes your address for service and enough information to indicate a breach of either the Human Rights Act or the Anti-Discrimination Act. If we receive the complaint and we see that the complaint actually is an anti-discrimination complaint, so it includes allegations that amount to allegations of discrimination under the Anti-Discrimination Act, as well as human rights breaches, our first step would be to speak to the complainant and recommend to them that they have the complaint dealt with under the Anti-Discrimination Act. And the reason for that is that the Anti-Discrimination Act has more options for taking a matter through to a hearing, if that is something the complainant wants to do, and it also has more opportunities for resolution through financial compensation, if that's what the complainant is seeking. And there's also no requirement for the 45-day waiting period in the internal complaint.
Right.
So if we get the complaint, it's an anti-discrimination complaint. There's also human rights breaches, but they haven't been through the internal complaint process. We can just treat it as an anti-discrimination complaint and run with it that way. If it is just it is only human rights and it's not anti-discrimination allegations, then we will see if there's another agency that might be more appropriate to deal with it, where there might be a specialty. For example, if it's an information privacy complaint, then the Office of the Information Privacy Commission specialises in that area. They can provide financial compensation, and they also can refer the matter on to QCAT. So we'll see if there is a more appropriate body to deal with the complaint, and the Act provides for us to do that. And we also investigate just to see what's already happened in relation to the complaint. We may speak to the public entity and see whether there's been some statutory compulsion for the decision. So if there was no discretion in relation to the decision that was made because of a piece of legislation that required the public entity to do something that was not consistent, not compatible with human rights, then we won't accept the complaint because it's not in breach of the Act. There might not be even many decisions like that, but if it's clearly not a breach of the Act because there was a statutory authority to do it, then we won't be accepting that complaint. And we also will look to see if there's any other concurrent proceedings, just so that there is one streamlined approach, so that we don't want to have the same complaint running in various different jurisdictions. Is there the next slide? So if we do accept the complaint, then the respondent will be given a copy of the complaint, they'll be notified about it, they'll have an opportunity to make submissions about the complaint. We may seek documents or some submissions from the parties so that we can better understand what the respondents are saying and also what the complainant is concerned about. So that's again working with the parties to work out what the issue is and really working hard to resolve the issues between the parties. The next slide. There's also a lot of options in the Act. Under the Anti-Discrimination Act, we really focus on conciliation and we move to quickly bring matter to conciliation if that's an option.
Yeah.
The Human Rights Act has more options available for looking at ways to resolve the complaint, and we may be talking to government agencies to see if we can resolve the matters more quickly or in less formal ways. And we really don't know how many complaints we're going to get. We may get many complaints, so we're not going to be able to take all of those to conciliation. We might get a lot of complaints that are the same type of complaint that we haven't been able to resolve, and those matters we may not take them to a conciliation conference. But we do have reporting functions as well. So, for example, if there was the same sort of allegation being made over and over again, the Commission has the ability to report about that publicly, so that those issues are brought to the attention of the public and the government to see if something can be done. So for the other matters where it's a human rights breach and we want to try and resolve the matter, then we'll have a conciliation conference where we'll sit down with the parties and we'll talk about what's happened, but also we'll explore what was the legislative authority, what was the authority for the public entity to make their decision. So to restrict people's human rights, there has to be some sort of legal authority for them to do that. So we'll look at that. We'll also look at whether there were other less restrictive ways of taking their action, of doing what they were doing. So we'll be exploring all of those sorts of things, and then looking at ways that the matter can be resolved. And that usually would be in a change of practice, possibly change of policy. So all of those things to try and resolve the complaint. But yeah, just the next slide I think is a diagram. So I won't go through that in detail, but basically at the end in the bottom left-hand corner it says complaint closed. So basically if it's a pure human rights complaint, there's no option for referral afterwards, so there's no tribunal afterwards. So our aim is to try and resolve the complaint between the parties, let them know the outcome of that, whether it's resolved or not resolved. And in some cases, if the matter isn't resolved, then we may make a recommendation to the parties as to how the public entity may have acted more compatibly with human rights.
Yeah.
And I think that might be my last slide. Yes.
Yeah, so now we're up to question time. So if you have any questions, please send them through in the question box on the right, and we'll sit here for a bit and answer them. And we're doing really well for time. We've got 10 minutes until 11, which is when we officially close our webinar, but we'll stay on a bit longer for you. So I can see some questions are already coming through. So I might read the questions out and then whoever wants to answer can jump in. So somebody has asked, and I think this person asked this question maybe during Janelle's part of the presentation. So they've asked, these rights are subject to limitations such as public interest, etc. Will it mainly be case law that determines when it is considered reasonable or justified to limit the rights outlined in this new Act?
Case law plays a role in helping to understand it, but I think it's a bit of a common sense approach as well. There is a provision in the Human Rights Act in section 13 that explains how human rights might be limited or balanced against other purposes. But basically you ask, does the policy or decision limit human rights? If yes, by that limitation, is that a legitimate objective? Is it something like public safety, or is it balanced against another human right, for example? And then is the limitation reasonable and justifiable? So, for example, is it the least restrictive possible thing that you could be doing, or is there another alternative that could have better met that person's human rights? So that test has been applied in quite a few cases, and that's how case law might help to inform it. But each situation is going to be unique, so a public entity would need to turn their mind to the particular facts of each case.
Okay, I've got another question. Someone says they've got clients with a disability and with disadvantages. Can you tell me more about meeting the disability policy to get help from legal aid?
We haven't finalised our grants yet for representation on human rights matters, so I can't speak with authority on that. But for example, our process around discrimination complaints, which is quite a similar process, we will help people to write their human rights complaint if they have vulnerabilities, which might be about their disabilities or other things that make the impact on their literacy or their capacity to prepare a complaint. And as usual, the legal aid tests are based on the means test and the merits test. So legal aid is really for the people who can't afford their own lawyers. So we look at how much money you've got, and then we also look at, whether we think you do actually have a case.
Okay, so someone's asking, does the Act apply to federal agencies such as the Department of Human Services, Centrelink, Child Support Agency? That's a good question.
No.
No.
NDIS providers are covered under the Act, though, so that's a little bit of a point to note.
Yes.
The providers, not the agency.
Okay. Does the Act cover volunteers and volunteers involving organisations like the Anti-Discrimination Act does?
Well, possibly could. If they're a volunteer working for, say, a government-owned corporation, then they certainly could be public entities under the Act if they're doing that work. So that, yes, it is possible. When we receive a complaint, that's part of our preliminary inquiries. We'll be finding out what was the role the person was performing and whether or not they are a public entity. But just because someone's a volunteer wouldn't exclude them from the operation of the Act.
So this sort of follows on to someone else who submitted a question earlier saying, are neighbourhood and community centres a public entity under the Human Rights Act?
Janelle, you might be.
I think I'm going to take the lawyer answer and say we'd encourage you to get legal advice if you're concerned about whether you might be a functional public entity or not. I wouldn't want to say yes or no to that.
Yeah. So, I mean, the Act does give some guidance about what is a public entity. So, a public entity is an entity whose functions are or include functions of a public nature when it is performing the functions for the state or public entity. And then there's also a lot more guidance in Section 10 when is function of a public nature. So that includes whether the function is conferred by statutory provision, whether the function is connected or generally identified as a function of government, whether it's for regulatory nature, and also an important one is the funding, so where is the money coming from, so whether the entity is publicly funded to perform the function, and whether it's a government-owned corporation. So there's no real clarity in the Act. It does provide quite a lot of guidance for you to work out whether or not you're a public entity. But again, as I was saying before, this Act is really a new way of making decisions in Queensland and embedding a culture of respecting people's human rights. So if you're not sure if you're a public entity, it's probably a good idea to look at this Act anyway and think about how you can be part of this, because this is a positive thing for Queensland and for your clients.
And you can choose to opt in if you're not a public entity and you want to be bound by the Human Rights Act. You can opt into it.
And if that's not formal, you can do that informally as well and decide that we're going to make decisions in accordance with this Act.
All right, a question has just come through. In regards to social housing, so a person can argue to stay in the house if he or she has been living with another tenant whose only name is with the department.
Those case studies tended to come out of case law down in Victoria. There are quite a few cases down in Victoria that are to do with housing. Yeah,
so I think it is. Yeah, so it would be an argument. So if it was a residential tenancy application, for example, so I didn't talk about the other type of complaint people can make is they call them piggyback actions. So if you have, say, a residential tenancy dispute, that can bring your human rights matter to the courts. So if someone was arguing that they wanted to stay in the property when they're being evicted, they can argue that it's a breach of their human rights as well as whatever their rights are under the Residential Tenancies Act. And certainly there's a case, I think it was Sudi in Victoria, that's the one case. So I did say Sudi, and that was in relation to very much a case like the Molly example that Janelle was talking about, and they decided that that tenant whose mother had passed away was entitled to stay in the property with his child, I think it was. So yes, it's just another consideration that you do have to take into account. So if a person's in the property, no one else is taking over the property, they're looking after the place and they seem to be a good tenant. Should we let that person stay in that property? Is there a reason why we have to take them out? So if an option is to keep them there, and then think about that. If there are reasons why you must remove them because of other laws or obligations, then you have to take those into account as well. So again, it's a balancing act.
Yeah, it's about making the most reasonable decision in the circumstances.
All right, somebody's asking a question about the NDIS. You mentioned that NDIS providers fall within the ambit of the Act. How are choice and control principles and open market concept reconciled vis-a-vis right to access services?
Look, I'm not sure about the right to access services. I don't think that's part of the Human Rights Act, and we're not going to be taking complaints about people's packages under the NDIS Act, if that's what the query is about. It's more about how those services are delivered. So the NDIS Commission also has a very complex and comprehensive complaint management mechanism, which does itself, I've had a look at that policy, respect people's human rights and take people's dignity into account. So the Human Rights Act is more about the delivery of the services rather than the actual granting of the package.
So maybe, for example, if an NDIS server says, I refuse to take you out of your house on a day that they're meant to be, that might affect someone's freedom of movement.
Or if the services are being delivered in an inhumane way.
Yeah, like the case study. If that was an NDIS service provider, then
that's right.
Yeah.
So
good questions. Someone's also asked, do you have to have the right and it taken away in regards to property? For example, is there grounds for homeless people to claim rights due to lack of affordable public housing?
Property is about the right to maintain your property in accordance with law. So it wouldn't give a new right to get property for a homeless person, that particular right.
It's about owning, right to own property alone in association with others.
But homeless people, for example, a family who's homeless, that affects their family life. It might, if they've got kids, that would affect the rights of the child. So there may be other avenues of that person's right.
The privacy and reputation, the right about privacy and reputation, it talks about a person has the right not to have the person's privacy, family, home, or correspondence unlawfully or arbitrarily interfered with. But I suppose that's really having their home arbitrarily interfered with if they have a home. So, I mean, that might apply to a homeless person who actually has established an area as their home and they call that space their home. Arguably, that may be, but there are also other rights that would impact on that possibly as well. So I'd say, I don't know how much case law, but yes, the Act would apply to homeless people in some ways, would give them more rights, I'd say, than they currently have.
If they were turned away from a health service because they were homeless, or if the children were denied education, or they were denied education, those kind of things.
Yeah, so any interaction that they have with government their human rights must be respected.
Yeah.
Someone's also asking what support can be provided to, this is more a question for you, Deborah, what support can be provided to people who wish to make a complaint but they can't speak, read or write English?
Yeah, they can come to our service and we can have an interpreter. So if they call on the phone, then we would have an interpreter on the phone to speak to them. And if they wish to make a complaint in another language, then we can have that interpreted from their language into English.
Okay, that's good for everyone to know. Okay, another question. There is no right to a healthy environment, but are there other ways to give effect to this human right?
Well, right to life is one of those. So if there's if there is something in the environment that is causing a risk to life, then the argument would be right to life is one of them that I can think of.
There is under cultural rights, there is a right for Aboriginal and Torres Strait Islander people to conserve and protect the environment and productive capacity of their land, territories, waters, coastal seas and other resources. And also there's a right to public life, which includes participation and consultation rights.
Would there be anything under the children's rights?
Potentially, I haven't heard of any particular cases. But
yeah, just thinking about like the public trust cases in America that you're denying, I guess, from a climate change perspective, that you're denying a person's right to freedom and liberty and those kind of things because of the environmental destruction that's occurring now. So that forward thinking, are we making sure that children are going to have a good life in the future? But that might be a bit of a stretch.
That might be a claim they have in the future.
Yeah, exactly.
I've got a section of textbook about that, so I can send that to you.
You know who that person is, don't you? Yeah. Okay, we've got another question. The Residential Tenancy and Rooming Accommodation Act gives QCAT the right to evict people living in public or community housing, rendering them homeless. Is this a breach of the Anti-Discrimination Act?
So, I mean, it could, when someone is evicted from their property, if it's because of a protected attribute under the legislation, then yes, that could be a breach of the Anti-Discrimination Act. So as well as bringing a claim to QCAT, they could also bring a complaint to us that they've been treated in a discriminatory way, that they've been treated that way because of their attribute. So there could be two claims running at once. Yes.
And of course, it could be under the Human Rights Act as well.
Yeah.
So in their QCAT complaint regarding residential tenancy, they could raise their human right.
Yeah. Great. Okay. So if you've got any more questions, feel free to send them through. Otherwise, I'll be going through the questions that some of you submitted when you registered. Okay. So someone else is also asking, what impact will the Human Rights Act have on QCAT matters, particularly anti-discrimination matters?
Well, with the anti-discrimination matters, from my assessment, most anti-discrimination complaints will also have a human rights claim within them. So that human rights claim will be one of those piggyback actions. So the QCAT will have to decide whether or not there's been a breach of the Anti-Discrimination Act. But if that fails on technicality, there'll also be, in most cases of discrimination, a human rights complaint as well. So even though they might fail on the discrimination claim, they might actually succeed on the human rights piggyback action. That won't mean they can get any financial compensation, but there could be an order made by QCAT that there be a change of policy or a change of practice. So I think it really strengthens anti-discrimination complaints because it really gives it extra law underneath it, protecting human rights.
I think I just saw a question about representative.
This one?
Yeah.
So the question is, can a disability organisation make a representative complaint under the Human Rights Act. For example, a government department implements a system which is inaccessible and therefore prevents people with a disability from gaining employment with that department.
So the Human Rights Act provides that all individuals in Queensland have human rights and only individuals have human rights. So I don't think it allows for representative complaints.
Although that would be a discrimination.
However, yeah. So you've got the two angles of one is just lodging a human rights complaint, or one is doing the combined action that Deb talked about before. So if there's a capacity for a representative complaint on whatever action you're piggybacking that combined action on, that would be how that might operate.
So the Anti-Discrimination Act does allow for some representative actions. We don't do them a lot because the Act is a little bit complicated in relation to sort of class actions or representative actions. But there could be a number of people who make the same complaint about their discriminatory treatment in employment, and we could deal with that. And there could be, as Matilda says, human rights could be part of that complaint as well.
All right, so somebody's asked, in a tenancy situation, what is an internal complaint? Would making a complaint to one's lessor or real estate agent count as an internal complaint?
Yes, it would if the lessor is a public entity, or a government entity, or a non-government entity performing a function of a public nature for the government, funded by government, basically.
Yeah.
So yes, that would be enough to make a complaint to the person who's providing the service to you. So yes, the tenancy provider.
But it's unlikely in a private lease arrangement with a real estate agent that the Human Rights Act wouldn't apply to that circumstance. So yeah, right. It's about the public nature, so public housing, social housing, those kind of things.
Yeah. But there is a big, under the Anti-Discrimination Act, there's a lot of protection for tenants. So if there's an issue about tenancy, it's worth having a look at the Anti-Discrimination Act. Again, look at the Queensland Human Rights Commission website. It still has a lot of information about discrimination as well.
Yeah. So there's an interesting question somebody wrote in when they registered, and it's what rights do incarcerated women have in terms of obtaining a family lawyer for a family law matter?
My understanding of the Act is that it does allow for the provision of legal aid, but not really beyond what's already provided for in the Legal Aid Act.
Okay.
But any decisions that legal aid makes about whether or not to grant that incarcerated woman a family lawyer will need to take into account her human rights, because legal aid is a public entity.
Okay. If there's any more questions, send them through. Otherwise, I think we will finish up. I'll give you a couple more seconds. All right. Thanks, everyone, for coming today. There's some general phone numbers on our slide if you ever need help with legal aid. We've got an Indigenous hotline now as well, which we're very proud to have. So if you have clients who are Indigenous, they can call that phone line for some culturally appropriate services. We've also got a youth legal advice hotline and a bushfire legal helpline, which is active at the moment with all the bushfires, unfortunately, that have happened around Queensland. Okay, those are where our office locations are, and most importantly, this webinar will go straight up on our YouTube channel in the next few days. So you can subscribe to our YouTube channel if you'd like to see it. Otherwise, I will be sending around an email to everyone who registered with a link to that YouTube video. If you need any publications or fact sheets, Legal Aid has free publications available on our website, and you can download them and you can get some to put in the foyer of your community legal service or your organisation. And feel free to follow us on social media if you'd like to know more about what Legal Aid does. But thank you very much for Community Legal Centres Queensland for joining us today, and also the Human Rights Commission for joining us today. So thank you very much, everyone, our presenters, and we'll see you at our next webinar, which will be in October, but we're yet to release what it's going to be about yet. So stay tuned. Thanks, everyone.